Thank you everybody for attending our latest webinar. This one is on cost-effective challenges to patents and patent applications. My name is Ben Appleton. I'm a partner at Wilson Gunn, and I have 20 years or so experience in patent prosecution and also in challenging patents via the various routes that we're going to discuss today. So in this session, we're going to discuss the main options for challenging problem patents or patent applications. And of course, it shouldn't be forgotten that the same options can be used against your patents and patent applications by your competitors. Now, the main ways of challenging patents are listed in the slide here. Third-party observations is the first one we'll discuss. This is the simplest and quickest way of challenging patent applications. There are a number of drawbacks that others don't, but equally there are a number of benefits to challenging a patent application using this route. Secondly, we're going to discuss oppositions. This particular process is more formal. It's generally held either at a patent office or in some countries in front of a court, but it's a sort of middle ground in terms of cost and complexity. And then thirdly, there is the process of revocation actions. This is generally a very formal process at a court or a patent office. It can result in significant damages and costs to the losing party, and so it's slightly less, well, it's less used than the other options by most companies. We're also going to discuss ways that you can help when the business wants to challenge a patent, and believe it or not, amongst all of the arcane and mystic legal rankings, your technical input can actually be key to winning any sort of challenge. Before we move on, we have to ask ourselves, why do we actually want to challenge patents at all? Why not just try and avoid them or just plow on ahead with product launches if you think that the patent shouldn't have been granted? Well, the answer to the first question, why not just avoid them, is that you often can't. If there's a granted patent and it covers the product that you actually want to produce or sell or license, and you can't avoid it by designing around, then it's going to be impossible to avoid unless you try and knock it out. The answer to the question, why don't you just plow on ahead with product launches if you think the patent shouldn't have been granted? Well, that's one of risk and liability. You might think that a patent shouldn't have been granted or a patent application shouldn't be granted in the future, but a court may very well disagree with you. In the meantime, if you've sold seven-figure sums of product or six-figure sums of the product in the meantime, which infringes that patent or patent application, you are going to be liable for significant costs and damages, potentially an injunction against you to stop you from continuing selling, and even legal costs, which again can be very, very pricey, 6 or 7 figures. So it's an incredibly risky gamble just to try and ignore it. No business is really going to accept that risk, which is why patent challenges and freedom to operate searches to avoid patents in the first place should be done by all businesses. So the first thing to consider is the difference between a patent versus a patent application. And we'll consider this before moving on to the different challenges. So a patent is a granted right. It can be enforced at any time after grant until patent lapses, and most patents can last 20 years from filing, so it can be there for quite a long time. So if a granted patent is considered a problem to the sale or manufacture of your products, it's a problem now and for as long as it exists. On the other hand, a patent application hasn't yet granted. Not only might the claims be amended or refused before grant during examination, and then they might no longer be a problem once granted, but also steps can be taken by you to try and force amendment of those claims, even if the patent office doesn't request it during examination. So it's a potential problem rather than an actual problem. It may well end up being an actual problem, but the risk can be assessed. Products can be tweaked to design around what you think the patent will eventually end up claiming. So a granted patent is a problem which is urgent to deal with, and you might end up spending a lot more to challenge it compared to a patent application. And the reasons for challenging a patent, well, just touched upon the fact that patents might be a problem. And a granted patent could potentially read onto products that you're already producing or manufacturing or selling. This shouldn't really happen because most businesses will undertake freedom to operate searching to try and identify patents and try and avoid them before they actually start selling a product, or they'll challenge them, as we're going to come on to. And if you've been selling something or manufacturing something since before a patent was filed and then granted, that patent may actually be invalid because of your own prior use. Another reason for challenging a patent is that the patent covers something you want to do in the future or may want to do. And this is probably the most common reason for challenging a patent or a patent application. You are intending to manufacture or sell something, you do your freedom to operate searching, and you find a patent application or a patent which you think is going to potentially stop you from doing that. So you might want to challenge that particular patent or patent application. Sometimes you might simply want to send a message to a competitor that you think they're trying to monopolize areas that should be free for all, or that you won't let them monopolize areas that you are interested in without a fight. And sometimes that can help in terms of clearing the way for products that would otherwise not be able to be sold because of those patents, but it may equally make sure that your competitors are less likely to file lots of patents and patent applications knowing that they're going to incur costs of challenges. And then finally, you might just want to keep your competitors guessing. So for example, if they file a series of patent applications covering a bit of technology, only one of which is a problem to you, you might challenge some or all of them because this way you're keeping your competitor guessing. They don't know which one of those patents is necessarily the problem for you, but they know that you're interested in making sure that some of those patents, or at least one of them, is a problem and that you want to knock out. So there's lots of different reasons for challenging patents. And depending on your business, some of those will be more useful or more likely than others. So on to the actual options. I'll go through the three main options that I mentioned: third-party observations, oppositions, revocation actions. But there are other lesser used options, some of which are only relevant to specific countries. That it's not really the forum to go through all of those now. But if you are interested, I can let you have advice on that later on. So what options are there? We've mentioned third-party observations. These can only really be filed against pending applications in most countries. Not all countries have them. And in fact, I would probably say that less than half the countries that allow you to have patents have third-party observation systems. And they're generally filed at a patent office rather than in court. So they're a very informal way of trying to challenge a patent application. And we'll come on to the pros and cons of that in a few minutes. The second one is oppositions. These are filed against granted patents in most countries. And a lot of countries have this system. So for example, you can file an opposition against a European patent. You can file oppositions against Indian patents, Australian patents, etc. Some countries do allow formal oppositions against pending applications, and one country that allows that is India. Not all countries have opposition systems. So, for example, the UK and the US don't have opposition systems against granted patents. They have different ways of challenging patents. And they're generally in front of a patent office, as I've said, but again, in some countries, it might be in front of a court. Then comes revocation actions. So these are your sort of traditional legal action that most people will think of, with barristers and lawyers fighting out and trying to revoke patent in front of judges. They can actually be filed against patent offices, a proper revocation action in some countries, including the UK, but most often they are filed in a court. And that comes with all of the associated costs and issues with any sort of court action. So a lot of the time they're a last resort. Some of the lesser known ones, there is the reopening of examination. So this is in particular in the US. Once a patent is granted, this is effectively the equivalent of third-party observations against a granted patent. It is really specific to certain countries like the US, and what happens is you file some observations once the patent's granted. The examiner reopens examinations to check whether or not they're relevant. If they're not, the patent remains granted. If they are, examination is reopened. You could also just simply write to the patent owner if you think that they have a patent which is invalid, and it might just work. If you contact the patent owner and present some or all of your arguments and evidence and invite them to withdraw the patent application in order to avoid unnecessary expense, a drain on resources, etc., for both parties, they might just decide that actually they don't want to fight. So it probably won't work because you are telling them that there is a problem with their patent, and they might think that the patent is valid, so they're likely to then try and keep it. You're alerting them to the fact that you're bothered about the patent or application, but if the arguments and evidence are sound, it might work. It might also help if you end up going down a different route, such as a revocation action, because if the patent owner has already seen that evidence and refused to withdraw that patent or patent application, then a judge might look quite unfavorably if they then lose the action and award more costs and damages to you. So it's a double-edged sword. It probably won't work, but it might in some cases. And again, the flip side is defending against challenges. Anything you can do, your competitors can do to your patent applications. And while there are differences in how you deal with defending against a challenge compared to launching one, the process is pretty much the same, just in reverse. So for the purposes of the rest of this presentation, we're going to assume that we're challenging a patent rather than the other way around. But you can imagine that the same sort of factors are factored in when your patents are challenged as well. So third-party observations, they're quite common. They're getting increasingly more popular, especially in Europe. And I have quite a lot of experience in this, and I think it's a great way of trying to challenge patent applications. So what are they? We've mentioned that they're not really against granted patents, only pending applications. And effectively what you do is you simply write to a patent office and you say, this particular patent application should not be allowed, don't grant it because of one of the following reasons. And I've listed a few reasons there. So the first one is lack of novelty and inventive step, or obviousness in the US. They're the main attacks. All countries that allow observations will allow you to attack a patent application on the basis that the claims lack novelty or inventive step because there are older, earlier documents or disclosures which describe the same or similar subject matter. In Europe and a few other countries, you can also challenge a claim using third-party observations on the basis that it's not sufficiently described or it's not supported by the application to the point where actually that invention can't be worked if you read the claims. For example, a claim might say that a product is produced by a very broad process, but in fact it requires a very specific step that isn't actually disclosed in the application as filed. So anybody trying to work that patent claim can't actually do so without finding the missing step. In other words, they have to actually invent to get your invention to work, and that's called insufficiency. And in Europe and some other countries, that would lead to revocation of the patent if it was proved. And then finally, in some countries and regions, if a claim has been amended during examination, so let's say it's been narrowed down because the original claims weren't considered novel and inventive, but that amendment isn't actually found in the application as filed, this is called added matter. It can be challenged after the patent's granted, and if the claim is then found to have such unallowable amendments, the patent can be revoked. And it's a particularly horrible way of losing your patent. It's a catch-22 position. They can't keep the claim because it's added matter, but if they try and remove that added matter, then the claim will be broadened after grant, which also isn't allowed. So they're stuck. The patent can't survive at all, which is very frustrating once you've got a granted patent. And so in this case, you're doing it before grant. They do have the option of putting back in the information they've taken out or taking out the information they've put in, but it's still quite a useful way of attacking a claim that you don't want. And what's the aim of third-party observations? Well, the obvious one is you want to prevent that patent application going to grant at all, but it could also be just to narrow the claims before grant if you can live with a narrower claim. Because sometimes you're looking at a claim, you're thinking, well, my product or process falls within that scope, but if they add a few extra features into that claim, my product or process won't fall within scope. So all I want to do is get that patent narrowed to add a few extra features of the patent claim, and then I'll be okay, and I don't mind if it's granted with that particular claim. So that's really one of the main ways of trying to get around patent applications before they grant. Usually the application is also obviously one of the main aims, because sometimes no matter how they amend the claims, you're still going to have a problem with it, and therefore the only thing you want to do is actually get that revoked. So what are the benefits and the disadvantages of filing third-party observations? Well, the first one there is that they can be anonymous, and in some cases is very important, and it's good. In Europe, you can file anonymous third-party observations. You don't have to say who it is who's actually filing those observations. And this means that you can probe, you can make mischief, try and limit a patent claim without the patent owner, the patent application owner, knowing who's actually doing it. And from a corporate strategy point of view, this can be quite valuable if you don't want your competitor to know that you're the one who's concerned about their patents. Equally, sometimes you do want your competitor to know that you're the one who's actually filing the observations and you don't do it anonymously. But I would say that the vast majority of third-party observations that are filed, at least in Europe, are done anonymously, because it's a way of knocking out a patent without the competitor knowing who's doing it. The fact that they can be filed anytime up to grant is also really, really useful, because you can keep probing, nibbling away at the claim, and hopefully persuading the examiner that the claim's quite obvious or not novel. If you fail or you only partially succeed, and the patent's still a problem when granted, you still get a chance to oppose the patent or knock it out through a revocation action. So you have got nothing to lose really by filing at least some observations and trying to narrow down that patent or knock it out before it's granted. It's also relatively cheap. Now, from my point of view, it might cost £2,000 to £5,000 to file third-party observations, maybe file a couple of follow-ups, etc. It might not sound too cheap, but when compared to the other options for challenging patents, it really is. And especially if you do knock out that patent or get it amended so that it's no longer a problem, that's a really, really cost-effective way of doing so. Another option is you don't have to use all of your attacks. You can save some in case you need them during a subsequent opposition or revocation action, and you can tailor your observations to force the applicant to admit things they'd rather not admit. For example, amend the claim away from your products, and generally ensure the patent owner will then have a very hard time of trying to accuse you of infringement. And then finally, another advantage is you can actually file multiple third-party observations. So if you fail first time around, and the examiner seems to be saying that no, they're going to grant that patent, you can file further third-party observations using different arguments, different prior art if you can find it, and you can do that multiple times. There's no real bar to how many times you can do that, so you get multiple bites of the cherry. The flip side is that, we've mentioned this before, when you file third-party observations, it does alert the patent owner that somebody is worried about their patent application. And so if they weren't particularly keen to spend lots of money on that patent application originally, or monitor for potential infringements, the fact that you file third-party observations will mean that they're more likely to think, well, this patent application must be useful because somebody's trying to knock it out, therefore I'm going to spend more time and resources trying to defend it. So it occasionally can backfire, but I don't think that particular disadvantage stop you from doing it. In the past, some examiners have seemingly just ignored observations that are filed, and this can actually, well, in the past, it made it harder to use the same prior art if you then did file an opposition or a revocation action afterwards, because you'd already used that prior art, you'd already used those arguments during third-party observations. The examiner ignored them. When you come to then try and attack it after grant, the patent owner and the courts or the patent office just say, well, these have already been considered, even if the examiner didn't say anything. This isn't so much of a problem now, because most countries that allow third-party observations have really tightened up on the fact that examiners can't just ignore it to make them, an easier life for themselves, and they do tend to look at them and comment on them, and are generally quite fair. And then finally, another disadvantage is it does use up some of your prior art, your earlier documents that you might want to attack the claims, and it might make it harder to use them during an opposition or a revocation action. This can be especially true in something like the US. If you filed third-party observations anywhere around the world and you've used certain documents, if you then want to attack the US patent after grant, it might make it really, really hard for the US examiner to say, well, actually, no, because those documents have already been assessed by other patent offices and they weren't deemed to be particularly relevant. Again, the cons, I don't think, outweigh the pros, and I think third-party observations are by far the best way of trying to challenge a patent application and make sure that it doesn't get granted in the form that you don't want it to be granted. On the screen is just a very brief sort of review of actual third-party observations that were filed at the European Patent Office. You can see it's incredibly simple, this one. It's literally listing the patent itself that you want to try and file observations against, the patent owner, which in this case is Nestec. You can see in the middle that the observations were filed anonymously. That's highlighted in yellow there. And the actual observations is just a single document, this de Klerk document here, and then an attack based on novelty. So whoever filed these observations said this patent application should not be granted because the claims lack novelty because of this document which we're submitting. Did it work? And the answer is yes. This particular slide shows the subsequent examination report at the European Patent Office. You can see that the examiner raised this document. It's the same de Klerk document. And they've then said, well, actually, this document seems to be relevant for both novelty and inventive step, and that document needs to be taken into account by the patent applicant before that patent will be granted. And just in case you're interested, this particular patent is still going through to grant, and this document has forced the patent applicant to change the claims quite significantly before it's going to grant, so it seems to have worked. And again, that third-party observation was probably incredibly cheap to file, but it's done its job of making sure that the patent applicant isn't going to get claims that are going to be a particular problem for whoever filed those observations. In terms of success rates, well, this is just a little pie chart that I made up. I took a sample of 40 applications at the European Patent Office where third-party observations had been filed to determine the success rate. And you'll see from this particular pie chart that 6 of those applications were either abandoned by the owner or they never went to grant, they were refused. 16 of them were amended, mostly quite significantly, and 18 remained unamended before grant. So in around 55% of cases, the observations can be considered success. 6 were knocked out, 16 were amended. And again, in most, the observations relied just on one piece of prior art, and so other prior art could be used to challenge an eventual granted patent. And it should also be mentioned that some of the observations were filed in Europe to force the patent owner to omit certain things, not necessarily for the sake of Europe, but those omissions could be used in the US, where any statement by a patent owner in any jurisdiction is binding. So even in the unsuccessful observations will in some cases have done exactly what they wanted to do and force the patent owner to say things and put that on file. So moving on to oppositions now. So what are they? So these are a much more formal process in which an opponent, in this case not an observer, they're an opponent, challenges a patent either just after grant at the relevant patent office or in some countries a lower court. But in some countries you can actually file an opposition just before grant, such as India. In terms of what happens, they're a pseudo legal action. So they're a bit more than just you filing observations and an examiner looking at it and saying, yes, okay, those observations are good. I'm going to say that this patent shouldn't be granted. This is actually at a relevant patent office in front of an opposition division or a judge or a tribunal panel. In Europe, they can be filed up to 9 months after grant of a patent, which is quite a lot of time to prepare. And in most other countries, you do get a few months in which to file an opposition once a patent's been granted. They are a pseudo-legal action, so I've just mentioned that before, and the result is binding on all parties. The results can generally be appealed in most countries, but if the appeal's lost, the original decision stands. This can mean that a patent is revoked just after grant if you do successfully revoke it, with no possibility of revival later on, and that can be incredibly useful. In Europe, the European Patent Office can revoke a patent centrally. So in one fell swoop, you can sweep away problems in every country effectively in Europe, including Germany, the France, UK, Spain, every other country covered. And it's a very powerful tool, because if you manage to do that, you revoke your European patent and it can't be reinstated, you just cleared the way across the whole of Europe. Not all countries have an opposition system. I've mentioned there the sort of main countries that do have really quite robust systems: Europe, India, Australia. But lots of countries such as the US and UK, if you're going down the national route, not through a European patent, they're not subject to oppositions at all. They are the middle ground in terms of complexity and cost, but the potential to move the patent in one go, never to return, is a huge draw. And in Europe, it's a very effective tool, and it's used quite often to try and knock out patents, even by relatively small companies with limited resources. So it's definitely the preferred option over a full revocation action. In terms of timelines, I'm mentioning the European Patent Office here because that's the jurisdiction I've got the most experience in, and it's by far the jurisdiction where most oppositions are filed. So this is just a quick slide to go through the process in Europe when opposing a patent. As you'll see, there's really only 5 stages: the opposition grounds being filed by the opponent, a response by the patent owner to defend that patent and argue against any of the grounds. A provisional opinion is then given by the European Patent Office. At this point, they might say, yes, the patent looks as though it shouldn't be, it should be revoked, or they might say, no, it shouldn't be. Equally, they might say, some of the arguments are good, some of them are bad. Once that provisional opinion has been issued, there is then a final round of submissions by both parties in response to that opinion. And then most of the time, there is a hearing called oral proceedings in Europe, and the decision whether or not that patent is revoked, maintained as amended, or maintained unamended is given actually on the day of the hearing, which is quite useful. The whole process takes 20 to 27 months from grant of that patent. It might seem quite a long time, or actually it might seem a very long time, but in the grand scheme of challenging patents, it's actually relatively short. Also, that time period gives the opponent, but also the patent owner, lots and lots of time to get their arguments and their case in the format and the shape that they would like as well. So it taking a reasonably long amount of time is sometimes quite a good system. The decision can be appealed. It's a very similar process, but with less flexibility for arguments and submissions. That will then take another 18 to 24 months. And I think by latest statistics, about 50% of opposition decisions are appealed. So on the whole, an appeal will be filed, especially if one party thinks that the decision was particularly bad for them. Pros and cons. I've listed the main ones here. There's certainly more pros than cons, at least in Europe and most countries. I've mentioned a few of them. The opposition or the appeal is final. There could be central revocation. One thing I haven't mentioned is that they are heard by technically and legally qualified judges or board members. That's particularly important because you are putting your case forward to somebody who's both qualified in the law, so they understand the legal arguments, but they're also qualified technically. They generally have a background in science and engineering, or the judges themselves will have clerks or people helping them who have a background in science and engineering. One of the pros is, I put it here, there's no examiner conflict. What do I mean by this? Well, with third-party observations, your observations go to a patent examiner, and sometimes patent examiners might think, well, do you know what? I know more than whoever's filing these anonymous third-party observations. I still think this patent should be granted, and I'm going to grant it irrespective of the arguments. When you file an opposition, the examiner isn't involved, or is not often involved, and instead it's heard by a board or a judge. So you remove that examiner conflict, and somebody who's incredibly impartial will have a look at all the arguments and the facts. The cons, the disadvantages, it can be relatively expensive compared to third-party observations. You are probably looking from start to finish an opposition anything between £20,000 and £40,000. In Australia, it could be anything from £100,000 to £200,000, so it can be really expensive. You can keep those costs down, and you can reduce those costs significantly if you're prepared to just file file very brief arguments, very brief facts, very brief evidence, and make sure that at all stages you're doing what you need to, but no more. It's also very deadline driven. There are lots of tight timelines for filing evidence and arguments, for responding to communications. It can be quite stressful and frustrating, especially if you need to do experimental work to back up some of your arguments. I won't really go through this. This is just an example of a European patent opposition. On the left here, you've got the actual notice of opposition that's filed. Again, like observations, you are simply setting out the actual patent application. You're setting out who the opponent is. Again, it can be filed anonymously, but in this case, it hasn't been. Unilever wanted to know that they were wanted Kraft Foods to know that they were opposing this particular patent. These are the grounds of opposition, or at least some of the first page, and you'll see that it's a lot more detailed. You have various arguments, attacks on novelty, inventive step, in this case, insufficiency or added matter, and then there are lots of documents that are filed as the actual evidence and arguments. So it's a lot more detailed, it's generally a lot more involved, which is why it costs a lot more to actually go through. A few statistics on oppositions. So this slide shows the current statistics for the European Patent Office oppositions, and also for the various technologies on the right there. Now, interestingly, you'll see that around 68% of oppositions are at least partially successful. So 26% of oppositions resulted in revocation of that patent, and a further 42 resulted in narrowing of the claims after grant. So I don't know about you, but I like those odds. And if patent's a potential block, there seems to be a strong argument for filing an opposition to try and clear that path for you. Of course, every opposition rests on its own merits. Filing weak opposition isn't going to work, no matter what the stats say. The high success rate that you see here is in part, I think, due to the fact that oppositions tend to be filed when the opponent knows it has a good chance of at least being partially successful, that is, amending or revoking patent. Because most companies, most individuals are not going to spend £20,000 to £50,000 filing an opposition that they know is quite weak. They're going to probably try and just change their product or their process to avoid that patent in the first place. So the high success rate of oppositions again at the European Patent Office is generally due to the fact that they are they're carefully filed by people who know that they've got a good chance of winning. And the stats on the right there really just show that the differences in revocation and success rate for various technologies. At the top here, you've got all of the software and electronics and communications technologies. They seem to have better success rates at revoking patents than a lot of the others. Third option, and this is definitely the most expensive and the least used, is full-blown revocation actions. These are formal legal proceedings, so it's generally a traditional court action or the equivalent in front of the really senior people of a patent office, such as the controller of the patent office or senior tribunal officers or panels of tribunal officers. The pros of filing them are that they are heard by a very, very senior and qualified patent judge or senior hearing officers at patent offices, and therefore their experience will count in terms of giving you a fair and impartial judgment. Judgments with a revocation action, especially in front of a court, are more likely to be persuasive to other jurisdictions. So if you knock out a patent in front of a court, say in Germany, the chances are that the French courts and the UK courts and the other European courts are likely to knock that patent out as well. And that way you can attack a patent in one country, say Germany, and then you could write to the patent owner and say, let's just not go through this, rigmarole, the costs, the exercise of doing this in the UK and France. Just give up your patents in those jurisdictions because you know they're going to be knocked out as well. So it can help in getting you a foot in the door in multiple countries, even if you only got a revocation in one. And they can be relatively cheap depending on where they are. Again, the UK Patent Office revocation proceedings, they are at the UK Patent Office rather than the court, and again, £20,000 to £50,000, which is cheap in the grand scheme of revocation actions. The cons, if they're actually in an action against a patent in the court, this is going to be really expensive. The minimum is going to be £100,000 in costs, and that can go up to 7 figures in some jurisdictions. They can be appealed, which could be even more cost, again, a minimum of another £100,000 for the appeal proceedings. If you lose, you will pay the other side's costs. So let's say you've spent £200,000 on a revocation action. The other side is likely to spend that. If you lose, you will be paying 50 to 70% of their costs as well. So they're really quite expensive, and you really have to carefully consider whether or not you've got the money for that. Judgments can still be erratic. In some countries, there are non-qualified judges. Very few these days, and most countries have realised that in order to have a robust patent system, they have to have specialised patent courts. But there are still a few countries that doesn't happen. And then in certain countries, patent cases are still heard by jury. This is in particular in the US. So you can imagine you've got a patent which is to do with a very complicated software implemented invention of a pharmaceutical, and you have to argue that case in front of 12 people, none of whom have any scientific background whatsoever. And you can imagine that this is going to come up with results that really do beg belief and are quite irrational or illogical. So you have to be careful in terms of where you're actually going to launch an action in countries where there might be jury trials as well. So based on the fact that there seems to be quite a few pros at all, and the answer is really you file it because you've missed the opportunity to file third-party observations or oppositions. There's not really any other way of justifying a revocation action unless you're a multinational corporation with lots and lots of money. So how can you help in challenging patents? Effectively, there's lots of things you can do. So the first one is you can identify patents and applications that might need challenging. So you're identifying things because you're the first line of defense for the business. If you're in a position where you're an IP manager, you're in R&D, you're going to come across patents that you think, hang on, this could be a particular problem. I need to flag this to the business to make sure that we are not at risk. Providing prior art. Once a decision's been made to oppose a patent or file observations, patent attorneys and other searchers can do a lot, but you know the technology. If you're in R&D, if you're in engineering, if you've been in that business for a long time, you can find non-patent prior art that would be really difficult otherwise to find. For example, you've got knowledge of textbooks, conference proceedings, prior products that have been on sale around the world. It's not going to be mirrored by your legal advisors who aren't really involved in that sort of thing and don't know about all of these resources. During a challenge, technical input. So this can sometimes help with arguments, but often the arguments are quite legal rather than technical once prior art is found. But at the same time, your knowledge of the technical side of these proceedings is going to really help in framing arguments based on what technical features are in the prior art and what aren't. Experimental work. Now, this one is really important. This is where you can actually shine. If you're in R&D or if you are controlling people in R&D, what we often find is that opposition failures is because we find something that we know should knock out a claim, but we have to argue that it's inherent in a document. So, for example, if the prior art examples and the patent example are repeated and show that we want them to show, then that argument becomes a fact and not just conjecture. So undertaking experimental work during any of these challenges is really, really key to success, and it can be the key to success or failure. It's a really underused role, and finding time to do that experimental work is really difficult. But my one bit of advice from this is if you can get people to do experimental work during oppositions, during third-party observations, then please do so, because that will really, really help. And could be the difference between success or failure, could be the difference between spending money and not getting anything out of it, or spending money and clearing the way for your product. And then the final one is very, very occasionally you might be called up to provide technical or commercial evidence during the proceedings. It's very rare, and it's normally during a court action, so a revocation action. But even in those cases, a neutral expert is used in 95% of the proceedings. So there's lots of different ways you can help. the experimental work is probably the most important thing you can do to help. I've really gone through this, but in terms of the fact that it's rarely done, why is that? And I've mentioned the fact that tight timelines is sometimes a problem. So I mentioned the European patent oppositions, you have to file them within 9 months of grant, and then once those proceedings have started, you have 2 to 3 months to reply, 2 to 3 months to respond and file further submissions, etc. But sometimes you have even less time because you have to review everything to determine what to do. At that point, if you determine that you need to do experimental work, it can be next to impossible to actually complete it in those time. So you have to be geared up to be able to set up experiments and run these as soon as your legal advisors actually say that. And I'm going to give you a quick example here of where it could help. So in this case, we're considering the following patent claim. This is a compostable chocolate packaging. It's comprising at least one compostable polymeric substance, so the actual packaging is made of a polymer, and it also includes seasonal crop plant fibers which have less than 5% lignin. So we want to knock that claim out. And what have we done? We've done some searching, we've found some prior art, and we found the first document which describes chocolate packaging, which is a film of polylactic acid. So that's a polymer, that's great. And it also has flax fibers, which have been processed by boiling water. So we do have those seasonal crop plant fibers. What's missing there is we don't know whether or not those flax fibers have less than 5% lignin. But we also find a second document which described that processing of sugarcane and cotton, both seasonal crops, by boiling in water reduces the lignin content to less than 3%. So that's useful to show that there are seasonal crops which comprise less than 5% lignin. Are those two documents enough to show that the claim isn't valid if we file an opposition or third-party observations? And the answer is probably not. And the reason is all that we've shown is that cotton and sugarcane, on the one hand, when boiled, have less than 5% lignin. But there's also a prior art document that describes a similar packaging to claim 1, but uses boiled flax fibers without proving how much lignin is left and without saying how long the flax was boiled. The European Patent Office is likely to say that there's no evidence that flax specifically is reduced to less than 5% lignin by boiling, even though cotton and sugarcane are. We all know that 99% certainty that yes, if you boil flax, it's going to be less than 5% lignin because all of the other seasonal crops that we found do. But without experimental evidence, the opposition and observations are likely to fail. That patent will survive and you'll kick yourself because all you needed to do was a bit of experimental work. And what would you need to do? So we would recommend, if I was doing the opposition, that business undertakes experiments to A, boil flax in water for various periods of time and determine what percent lignin is left after each time period, and then boil flax in water using any known standard processing of seasonal crops, and again determine the percentage weight lignin. Experiment A is going to hopefully show that boiling flax for even very short periods of time would reduce lignin to less than 5%. Experiment B would hopefully show that boiling flax using standard methods for flax processing would inherently lower lignin again to less than 5%. So both should be enough to show that our prior art, that document that we found that had polylactic acid as the film and boiled flax, is actually novelty destroying because it would inherently have less than 5% lignin because of the experiments we did. So you can see that even very simple experiments are going to really, really help in changing that from a failure in terms of the opposition or third-party observations back to a success. In terms of roadblocks, again, you can see that providing experimental results can be crucial, but it's rarely done. In fact, it's used in less than 5% of non-pharmaceutical patent challenges. Pharmaceutical patent challenges almost always have experimental evidence from both parties. And in most sectors, it's rare. But why is that? And really, the reasons on this slide are there. In general, there's not enough time. There's too many deadlines. In some cases, it's because experimental work doesn't appear to be vigorous or scientific enough, and actually businesses refuse to do it because of that, which I think is always quite strange. And then finally, sometimes people in R&D don't want to do it because they are worried that they're going to have to appear at any hearing and give evidence and sign off experimental work. But again, in most places, especially the European Patent Office and other patent offices, if you give evidence in the form of experimental work and you sign it off, you are not going to be asked to turn up at any hearing and speak. So most of these things aren't really an issue. They're just a perceived issue. And to this end, I would just say that even bucket chemistry experiments that cast doubt on the patent owner's case and helps ours is better than nothing. So it can be the difference between success and total failure. And that wraps up this session. Hopefully you've got something out of this. You've found out the different ways of challenging patents, the relative pros and cons of them, and how you can actually help if you do file one of these challenges in front of a patent office or court. Thanks for listening.